My guest today is Eddie Stone of Edward Stone Law in Greenwich, Connecticut. Eddie Stone is a former general counsel for J.G. Wentworth, and I have him on the show today to give his perspective on the Structured Settlement Protection Acts then and now. So Eddie, you were involved in the original negotiations and development of legislation for the Structured Settlement Protection Acts. Can you tell us a little bit more about your background in that area?
Sure. I got involved with J.G. Wentworth before there was 5891 or any state transfer act. The first proposed piece of legislation that came out, if I recall correctly, was in Illinois. And at that point, all of the factoring companies took the risk of diversion by the sellers of the payment stream. And this piece of legislation kind of came out of the blue, and that led to a series of negotiations in a variety of different states. And that ultimately culminated in the compromise, which was 5891, and then the creation of the state transfer statute.
And who were the parties, when you say there was a compromise, who were the parties that were negotiating these acts, and who was compromising?
Well, I mean, the NSSTA was leading the opposition to kind of factoring in general, and they took the view that factoring was a bad thing across the board, and a number of the companies, including J.G. Wentworth and others, banded together to try and create reasonable rules of the game for folks, because obviously the marketplace had spoken and people were very much in need of liquidity options, and the position we took was that offering liquidity to an inflexible structure was a good thing if it was done properly.
Okay, so the Structured Settlement Protection Acts initially had a very good intent, basically, they were there to provide some type of a process, a transparent process to, basically allow people to get liquidity for what previously was an illiquid financial vehicle, correct?
Yeah, that's right. I mean, what we realized was that a lot of circumstances changed. People developed liquidity needs, and many of the structured settlement recipients weren't able to go to their local banks and borrow money, and they didn't have a lot of alternatives. And the payments that they were receiving over time sometimes didn't fit their needs. And so we tried to develop a system that would allow them to access some liquidity with standards, which ultimately that best interest standard that would give some oversight and a third-party review so that they couldn't be done too easily, but by the same token, there would be a release valve in situations where liquidity was very important.
And who enforces, who's in charge of enforcing the Structured Settlement Protection Acts?
But, each state passes its own act, and so the states, it's all left to the states to enforce. The first order is to get a court order from an appropriate court. There's also this notion of an excise tax that's been built into the act, which really was created, in my view, just to be a deterrent to avoiding complying with the act. And the excise tax is designed to be a punitive tax. And so the first order of review comes at the court level, the trial court level, or the probate court, depending on what court hears these in each state.
Okay, now Eddie, that brings us to, I'd like to now fast forward to today. I mean, there's been a lot of press, not all of it good, concerning Structured Settlement Protection Acts between Illinois, in Florida, and in other places. Do you feel, how do you feel the Structured Settlement Protection Acts have worked in the last, we're talking about 13 or 14 years since the 5891 was passed, or 5891 was put into place? What are your thoughts? Do you think it's worked for the most part, or do you think that there's areas that could be improved upon?
Yeah, there's a number of areas that can be improved upon. I think that it's really incumbent upon the companies who are in the business to police this best interest standard. I think that if people look at the people who are selling and they look to provide liquidity and the transactions are in the best interest of the parties, in particular the seller, I think that what the provisions of the Act work fine. The problem is, in practice, the marketplace has moved to a situation where people are looking to do the largest transactions possible, the largest size, which is really contrary to the notion of the best interest standard. And I see a lot of that. I also see an enormous amount of forum shopping, where people are looking to find jurisdictions where there are no real review processes in place. Now, that said, you have to balance that with the fact that the court order process itself creates expense, which essentially prevents small transactions from being done. And arguably, the small transactions are the one that should be the most efficient, since it generally involves situations that don't involve, long-term needs, but they're smaller structures, and there's no efficient way to transact those. So those would be my major criticisms.
Okay, let's break down some of those particular issues. So when you speak of forum shopping, basically that's the efforts made by the purchasers or the brokers for the purchasers to get people into states where perhaps there's less effective coverage. Is that what you're saying?
Well, it's not so much coverage. The act is still the same, but they go to courts where they know they can get a deal done quickly, or in states where they shouldn't be in the first place. So, there are plenty of examples that all of you have read about where people have flown people from one state into a certain state because they know they can get them a quick driver's license, and then they can qualify them under the local statute. And, there's obvious potential abuses with things like that, particularly when you're dealing with folks who sometimes are not that sophisticated. That really comes down to companies looking at the standard themselves and saying, am I going to comply with the statute or not? And if you're flying somebody to another state to avoid a state law, you're really not complying with the statute.
So what are the consequences? Let's talk about the consequences. So you have, in the insurance business, people take people out to dinner, may go to a ball game with them, might give them a coffee mug. What kind of incentives are people being given to fly to Florida, for example?
Well, the incentives are a whole other issue. There's a rampant process of sending checks that people cash, and that kind of binds them to a contract. There's monetary incentives, people who are being told a lot of things that sometimes don't bear out. But at the end of the day, what it really comes down to is if you look at the statute and you comply with the terms of the statute, I think the business could work just fine. The problem is like I said earlier, the folks who are buying or brokering are looking more at how can I make the most money? Well, I can make the most money by doing the biggest transaction. So I'm going to disregard the best interest standard, and I'm going to try and get the biggest possible deal. Because a lot of this business has now gone to, from when I was at Wentworth, it was all done with institutional capital and major lines of credit. Now the business is becoming more and more about one buyer negotiating with one consumer and then selling into a high net worth market or to a money manager market, and they're selling something that's not exactly what they say it is.
Okay, that's very, very interesting. So that brings me again to the what are the consequences to an investor, perhaps an individual investor, to when the Structured Settlement Protection Act has not been complied with by the purchaser or somebody facilitating the purchase?
Right. Well, I think that there's always the risk that a transaction gets rescinded, which is something that has happened and probably will happen in the future, either because somebody has seller's remorse or because the practices that were involved come to light and somebody challenges it. I also think some of these practices are really bad for the secondary market. I don't think that they're necessary, and I don't think that they create that release valve that's so important for people who have inflexible payment streams. I think what it does is it exposes people to all sorts of challenges, whether they're legal challenges, regulatory challenges, or the like. And I think these types of challenges could be devastating for companies and, unfortunately, could paint the whole industry in a bad light. That's why I think that companies who are in this business, who are trying to do things the right way, should take it upon themselves to force people to comply with the spirit and the letter of the state transfer statute. That's fair.
That's fair enough. Let's go back to some of the aspects of the Structured Settlement Protection Act, and one of them is that each of these transactions requires a judge to approve the transaction as being in the best interest of the seller and, if applicable, the seller's dependents. Okay.
John, before you go on, I just want to make one clarification, a point of clarification.
Sure.
The statute does not speak to a judge passing on anything. It speaks to a court order. And that's kind of one of the challenges. Sometimes the court orders are rubber stamps. Sometimes they're the subject of very, very detailed court proceedings. And this is really an issue that cuts both ways. On the side of the factoring companies who are trying to do the business the right way, facing competition from folks who are not, you know, it's very expensive sometimes in a jurisdiction where a judge requires significant appearances, and there's the risk of a denial to get a transaction done properly. And that is one of the issues. The other issue on the other side of the coin is that people are skirting these issues, ignoring these standards, and taking cases into courts where they know they've got a friendly judge or a friendly clerk that's going to get them a court order that's not going to be the result of a third-party review.
Right. Do you think requiring the claimant, it seems to be the requirement of an in-person appearance by the seller, it seems to be an inconsistent requirement state by state. Do you think that requiring the claimant to, or the seller to actually be there in court where the judge can actually interview them, a similar process to what is required when an infant settlement is approved on the primary side? Do you think something like that would have some benefit?
I think it could, but again, you have to bear in mind to make this commercial, you can't do it for every case. It just becomes cost prohibitive. Litigation is very expensive. Court dockets are very crowded. Requiring personal appearances can be tough. I actually think that an easier way to do it would be to get an independent third-party review of a transaction. This is very often waived. Very often what happens is the individual waives the right to consult with a financial advisor or an attorney. There are plenty of people who could be accredited for this process, who have the skills and experience, who could provide the third-party review to sellers, and that would avoid a lot of these transactions, particularly transactions involving situations where the transfer statutes are being ignored.
No, that's fair. That's fair enough, because it seems to me that if you're on the primary side and you're talking about when someone says, well, what happens, the big what if? What happens if I do a structured settlement and an emergency pops up and I have no other way to,
right?
What do I do? And
John,
yeah, go ahead.
Sorry, John, but there are financial planners and there are attorneys who would be willing to review the paperwork, who know the way this stuff works quickly, who could come up with a series of questions that wouldn't take a long time, and those could be filed with the court. And that would provide a certain level of comfort. Number one, to the companies who want it, the factoring companies who want to do the business right, they'd have a certain level of comfort. And by the way, some of them do that. And some of the factoring companies, some of the reputable factoring companies, actually require in-person appearances for certain cases because they are concerned, because when they place something into a major institutional line of credit, they make reps and warranties to their lenders, and they have problems when those things don't pan out.